My name is Badass Benny and welcome to my channel. If you're an ACE, AMAC, or sex human trafficking survivor, you're in the right place. And it won't cost you a penny to like and subscribe worldwide, and please leave a comment below if you have any questions. Today, we're going to talk about court procedures in a sexual assault case. The District Attorney's Office is responsible for taking legal action against those persons accused of violating the law. Rape and sexual assaults, like other serious criminal offenses, are considered a crime against the state. Therefore, the Deputy District Attorney prosecutes on behalf of the state and not directly on the victim's behalf. He or she becomes a major witness for the prosecution. After the suspect is arrested, the law enforcement investigator gives his report and any additional information to the District Attorney's office. The District Attorney has 2 days after the suspect's arrest to make a decision about prosecuting the case. To make this decision, the prosecutor considers whether there is enough evidence and a reasonable chance of convincing the suspect. Usually the Deputy District Attorney will want to interview the victim in order to verify the accuracy of the police report, obtain additional information, and explain what he or she can expect during the judicial process. If the District Attorney's Office decides not to prosecute, the victim has a right to a complete explanation of how and why the decision was made. The defense attorney. The defendant may hire a private attorney to represent him or her, or she or he may be assigned to one from the public defender's office. The defense attorney or an investigator for the defense may attempt to contact the victim and request an interview. She or he does not have to speak with any representative of the defendant. The public defender's office should not be confused with the office of district attorney. If she or he is contacted by someone from the defense and has any questions regarding the contact, she or he should call the detective or the deputy district attorney, handling his or her case immediately. Bail. Bail is the money or bond that is put up by or on behalf of an arrested person to get out of jail before or after court proceedings begin. One purpose of bail is to ensure that the suspect returns for all court appearances. The amount of bail is determined by the seriousness of the crime, the suspect's previous record, and any potential danger to the public. Under certain circumstances, the court has the right to deny bail. The preliminary hearing. If formal charges are filed against the suspect, the Deputy District Attorney will present the case to a judge at the preliminary hearing. The hearing is usually much shorter than a trial. The purpose of the hearing is to decide whether there is sufficient evidence that a crime was committed and that the suspect in custody is the person who probably did it. The victim will receive a subpoena telling him or her when and where to appear. The Deputy District Attorney will meet him or her before the hearing to review the case and prepare him or her for testifying in court. The preliminary hearing is usually open to the public, but the suspect has a right to request a closed hearing. Under certain circumstances, the Deputy District Attorney can also ask to have the hearing closed. The suspect and his or her attorney will be present. The victim will be called to testify by the Deputy District Attorney. After the prosecutor has questioned him or her, he or she will be cross-examined by the defense attorney. If the judge decides that there is sufficient evidence that the suspect has probably committed the crime, an arraignment date is set. If the judge decides that there is not enough evidence, the case will be dismissed and the suspect released. The arraignment. The arraignment takes place after the preliminary hearing. It is not necessary for the victim to attend. At this time, the suspect is informed of his or her rights and the charge against him or her. She or he is allowed to enter a plea. If the suspect pleads not guilty, the judge will order a trial. If he or she pleads guilty, there is no trial and a date is set for sentencing. So postponements. There may be several postponements, continuances of the case before the victim actually testifies. She or he will receive a new subpoena each time there is a postponement. She or he is expected to appear each time a new date is scheduled. Some defense attorneys ask for repeated postponements as a strategy to wear down the victim. You should be aware that the deputy district attorney could oppose requests for postponements. It is up to the judge to decide whether any continuances will be granted. The trial. If there's a trial, it usually occurs several months after the assault. The victim will receive a subpoena from the district attorney's office to inform him or her to review the case and prepare for the trial. The defendant can elect to have either a judge or jury hear the case. The trial is open to the public. She or he may bring friends, family, rape crisis intervention advocates, and anyone who will provide support for him or her. She or he may request that his or her attorney will ask the judge to allow him or her to be in the courtroom after she or he has given his or her testimony. During his or her testimony, the district attorney will ask the victim to describe the details of what happened. She or he must tell the truth as clearly and fully as she or he can. If she or he does not understand a question, she or he must ask for it to be repeated or reworded. After the deputy district attorney has questioned him or her, the defense attorney will begin the cross-examination. These questions may be more detailed and more difficult to answer than those asked by the deputy district attorney. Because of the passage of time, many victims cannot recall all the details of the assault. If she or he does not allow the answer to a question that she or he once knew, she or he may simply state that she or he does not remember. And this is why it's important after sexual assault, if you can write down what happened immediately. I know that would be difficult, but try to do it. The defendant may choose not to testify after all the evidence has been presented. The judge or jury will decide the verdict. A verdict of not guilty means only that there was not enough evidence for the judge or jury to believe beyond a reasonable doubt that the defendant was guilty. It does not mean that the defendant did not commit the crime. Sentencing. If the sentencing is convicted, it may be weeks or even months before he or she is sentenced. The judge will probably make a request that a probation officer review the defendant's past and recommend a sentence. The probation officer should interview the victim and include his or her statement in the report to the judge. If she or he is not contacted and would like to express his or her position, she or he may write a letter directly to the judge. The possible sentences are premeditated in the penal code. Appeal. If the defendant is found guilty, he can appeal, or she. In an appeal, and her court reviews the case to determine whether any legal errors were made during the trial. An appeal can take months or years. The survivor will not be asked to be present during the process. The judge may release the defendant during the appeal, but this seldom occurs. If the defendant's claims are upheld on appeal, the case will be sent back to the trial court for retrial. Excuse me. Victim compensation. Any victim of violent crime that occurred in California may be entitled to financial assistance from the state. The Crime Victim Compensation Program is administered by the State Board of Control. To be eligible, you must have suffered severe financial hardship as a direct result of violent crime. 2, be a resident of California. And 3, cooperate fully with law enforcement authorities. So you have to have a case numbered. If you are eligible, you may be compensated for medical and counseling expenses and loss of wages. Application forms are available from the police, district attorney's office, hospital, emergency departments, and the victim witness program. Civil suits. A victim has a right to hire his or her own lawyer and file a personal injury suit in civil court. She or he may either sue the rapist directly or attempt to recover damages from a third party whose negligence may have contributed to the assault. He or she can sue for damages caused by the crime, including physical, psychological injuries, loss of income, and property damage. A civil suit is very different from a criminal prosecution. It is important for him or her to discuss these differences with his or her attorney. The average civil suit is not tried for 5 years. Before filing such a suit, I have GERD and gastroparesis. So if I just burp, that's how it is. If I vomit, I apologize. Before filing such a case, the victim should weigh with his or her attorney the social and financial benefits against the possible emotional stress of having to prolong his or her direct involvement with the rape incident. So, if you haven't received any help with victim compensation, it's not too late. So talk to your local RAINN or sexual assault center in your area. And what are you going to do to take care of yourself today?